the next 60 minutes, Megan and I are going to literally zoom through a bunch of cases on Zoom. And what we're going to try to do is just highlight the issues. We're not going to have a lot of discussion of the issues in depth, but Megan has prepared a very extensive handout. And that handout is being provided hopefully to all of the participants. It's, 45, 50 pages at this point, that will give you the opportunity to more fully explore cases that may have issues in them that are of interest to you. And so, with that, we're going to hopefully get the PowerPoint that we have prepared ready, and give me a second here and make sure we get to the beginning. All right. So since Megan and I are in different rooms, we're going to be talking to each other via Zoom. And Megan, do we look good on the PowerPoint?
Yep, it looks like it's good.
All right, so here we go. What we're going to do is we're going to try to touch every case that has been decided by the Maryland Court of Special Appeals, the Maryland Court of Appeals, and the Fourth Circuit, and the Supreme Court in the area of criminal law. And we're going to be talking about cases that are pending either decision or have been accepted for argument by the Court of Appeals and the Supreme Court. And so here we go. First case, Shannon versus State. In this case, the defense raised an argument that because the indictment had alleged a prior conviction for possession with intent to distribute a controlled substance and further defined the crime as a crime of violence, that made the indictment defective. The Court of Appeals held that the drafting error did not mean that the count failed to allege a cognizable offense. It wasn't necessary to amend it, and the court concluded that the defendant was not prejudiced by this, that the defendant was on proper notice as to what was being charged in the particular case.
All right, in State versus Zeta, this is a case out of the Court of Appeals that Judge Houghton authored, and this is a great case on severance if you want to read the whole opinion. In this case, pre-trial, the defendant moved for severance of defendants. He was charged with his girlfriend alongside of her for murdering her husband. And pre-trial, the prosecutor proffered that all of the evidence would be mutually admissible against both co-defendants. However, throughout the trial, it became evident that the evidence that was being introduced would not have been mutually admissible against Mr. Zeta. His counsel objected at least 9 times to various pieces of testimonial hearsay evidence, non-testimonial hearsay evidence, and other material that was irrelevant. The court did give 9 limiting instructions. However, the Court of Appeals held that those were essentially meaningless because of the frequency with which they were being given. Next.
Okay. I'm working on it. There we go. All right. So in Sales versus State, this was an interesting case because in this particular case, the photo array was essentially photoshopped. The fact that they were digitally altered photographs used in the photo array was not considered to be improper because the effort was made to make a facial tattoo not distinctive in the sense that it would draw particular attention to a defendant's photograph. So in this particular case, the photoshopping, while it changed the actual appearance, it also was held to eliminate what would otherwise be perhaps an impermissibly or unfair suggestive a photo array. In this case, in Green versus State, this is pending before the Court of Appeals. The Court of Appeals is going to consider the issue of a confirmatory identification. A confirmatory identification differs from a selective identification. And it differs in the sense that when we're doing a normal photo spread, a victim of a robbery is shown a bunch of photographs of people and doesn't know them outside of the robbery encounter and what's in the photo array. So they're selecting an individual from the photo array. A confirmatory identification occurs when, in this type of a case, an individual is asked to identify somebody in a video, in a photo array, but it's somebody that they had had prior contact with, somebody that they had known for years, had seen on a number of occasions, and is simply asking to confirm that the person that they know is the person in the photograph. And so the Court of Appeals will be considering whether or not the Court of Special Appeals was correct when they said you don't get a pretrial hearing on identification issues when it's a confirmatory and not a selective identification. Now we're going to go to a number of search and seizure district courts.
All right, in Williams versus State, the Court of Special Appeals held that the state violated the defendant's Fourth Amendment rights. In this case, the defendant was driving down the street while talking on the cell phone, and that's why the officer initiated the traffic stop. When the vehicle stopped, the defendant stepped out of his vehicle at the same time that the officer stepped out of his vehicle. The officer rushed the defendant from behind because the officer thought that it was abnormal that the defendant would step out of the vehicle. The officer testified at the suppression hearing that he thought that the defendant had something in his hands, but beyond that, he did not express what he thought the object was. The officer never testified that he was in fear of his life, that he feared for safety, that he thought that the defendant was armed or dangerous. The officer basically just charged the defendant, tackled him, took him down to the ground, and actually ended up pepper spraying him. During this time, there was evidence of a non-criminal amount of marijuana found on the defendant's person, along with a couple $100s in cash. After, subsequent to that takedown, the officer then searched the vehicle, in which he found a criminal amount of marijuana and other indicia of drug sales. The Court of Special Appeals held that this was an unlawful Terry frisk because the officer never articulated that he believed or had reasonable suspicion that the defendant was armed and dangerous. It was important to the Court of Special Appeals to note that a Terry frisk must be supported by particularized suspicion at its inception. So meaning at the time that the officer was rushing the defendant, and there was nothing prior to the takedown that would have risen to the level of criminal activity or danger. The defendant was simply talking on a cell phone while driving, like many drivers we see on the roads. The court also considered this as a de facto arrest and considered then whether there was probable cause to support the arrest, which the court held that there was not. And furthermore, the court held that the evidence would not have been inevitably discovered. That was the way that the state tried to save the evidence for trial. The state asserted that because the vehicle was going to have to be towed because it was on private property when it was stopped, that the vehicle would have been searched and the evidence in the vehicle would have inevitably been discovered. But the Court of Special Appeals said, no, state, where the arrest was not even lawful, that vehicle never should have been towed because that driver should have been allowed to get back in the vehicle and drive away. All right, this is the Zeta case again, which also held that the seizure of the cell phone from the respondent was unlawful. Now, we just talked about this case in the context of severance. The issue of severance, I think, took up most of the opinion, but there was also this important issue. In this case, the police had a search warrant to search the vehicle of Mr. Zeta. However, they did not have a search warrant to search his person. So when the police came in contact with Mr. Zeta to present him with the warrant to search his vehicle, what the police ended up doing was they frisked him. They felt that there was a cell phone in his pocket, which they recognized as a cell phone. The cell phone did not present to them as anything dangerous. It wasn't a weapon. And at that time, the police didn't have any reason to believe that the cell phone contained evidence in the investigation of the murder. So the Court of Appeals held that the officer exceeded the parameters of the plain field doctrine because it was not immediately apparent that the cell phone was incriminating. None of the other exceptions to the warrant requirement applied. All right, the next case, Thompson versus State. This case spends a lot of time talking about Frank's hearings, or what is needed in order to generate a Frank's hearing. And it also reviews the time limits that are put into place in terms of when you need to request a Frank's hearing. You must file a motion within 30 days of your entry of appearance requesting a Frank's hearing. Now, should you receive discovery after that point that generates an issue for a Frank's hearing, then you must file a motion within 5 days. And that was not done in this case. The court also wanted to make clear what the different standards are. First, for requesting a Frank's hearing, and second, if you are granted a Frank's hearing as a defendant, what your burden is at that point. So first, the defendant must make a substantial preliminary showing that there are material misstatements or misrepresentations or omissions in the warrant application. If a defendant is able to meet that burden of a substantial preliminary showing, then a Frank's hearing should be granted. At the Frank's hearing, this is when now the court allows the parties to go outside of the corners of the warrant application to bring in other testimony so that a defendant may try to prove its burden by a preponderance of the evidence that there were materially misleading statements. And in this case, the defendant was not able to do that. There was sufficient evidence, even excising the portions that the defendant was complaining about. There was a sufficient nexus to the residence that was searched and the crime at hand. Okay, next. All right, State versus Carter. This is pending in the Court of Appeals, and this is a pretty interesting case. In this case, it's all about what are called fare inspections or fare sweeps that occur on the light rail. And what that essentially means is that MTA officers will at various times have approximately 6 officers go to a certain station on the light rail. And the whole purpose of it, well, one of the purposes of doing this fare sweep is to make sure that the passengers on the train have actually paid the fare, that they're not just riding for free. So when the train stops, some officers remain on the platform while other officers enter onto the individual train cars. And it is at that point that they require every passenger to show them the ticket to prove that it was paid. If the ticket is not paid, or if the passenger doesn't have a ticket, the officers then require the passengers to exit the train car to go to the platform, where they must now meet with the other officers on the platform. Those officers then obtain the identification information of the passenger for the purpose of running a warrant check, in addition to writing a citation. But it came out at the hearing in this case that the real purpose is to run a warrant check. In this case, Mr. Carter did not have a ticket when the train was stopped and when Officer Russell or Corporal Russell entered the train. The way these officers entered the train is to it essentially prevents people from being able to exit. So that in itself is deemed a seizure. Once Mr. Carter was told to go to the platform, he provided his information. It became known that there was an outstanding warrant for him. He tried to run. He was tackled. There were, I believe, drugs found on his person, if I'm not mistaken, and I know that there was a gun and bullets found on the train tracks. The Court of Special Appeals determined that this was a seizure within the meaning of the Fourth Amendment, and that it was essentially unconstitutional, and that the attenuation doctrine was not applicable in this case. The Court of Special Appeals went through a number of factors as to why a person would not have felt free to leave, the show of authority by the officers, and what supported the detention. Likewise, they considered the 3 factors from Utah versus Strife. about the attenuation doctrine. The only factor that was in favor of not suppressing the evidence was the fact that there was an outstanding warrant. However, the temporal proximity between the unconstitutional seizure and finding the evidence was so close that supported suppression. And of course, the fact that these fare sweeps were being used basically as a basis to check for warrants also supported suppression. So the Court of Appeals has taken this issue up, and we will see ultimately what they decide. Also pending in the Court of Appeals is Lewis versus State. This also is an interesting case in which the Court of Special Appeals held that odor of marijuana on a person alone, that being the only factor, is sufficient for probable cause in order to search the person. In this case, there was a tip by a reliable source that a person of a certain description wearing a red backpack had a firearm in that backpack. A broadcast was put out, and a person matching the description was discovered at a store called a Bag Mart in an open air drug market, as the police testified to. When the officers entered the Bag Mart, they came in contact with Mr. Lewis, and the officer testified that he immediately smelled marijuana emitting from Mr. Lewis's person, and it was at that time that he searched the backpack, found the gun, and then searched Mr. Lewis and found other contraband on him. The Court of Special Appeals first considered the fact that Maryland courts have previously held in other contexts that odor of marijuana can support probable cause for a search. Likewise, the Court of Special Appeals considered cases from other states that have held that where the odor of marijuana on a person is specifically localized to that person and not just a general aura within a vicinity, that can support probable cause to search the person. And so it was a narrow holding. The Court of Special Appeals also refused to consider the fact that another officer first had seized Mr. Lewis by holding his arm prior to the scent of marijuana being detected. The Court of Special Appeals said that was not preserved, but the Court of Appeals has indicated that it may consider that in front of the Court of Appeals.
In United States versus Fall, the Fourth Circuit concluded that it would not reach an issue that was presented in the case. In this case, an individual, the niece of the defendant, found 2 laptops with child pornography on it, took it to the police station, showed it to the police officers, who subsequently got a search warrant to inspect the electronic devices. The Fourth Circuit indicated that they were going to apply the good faith exception and not reach the issue about whether or not a private search under these circumstances was something that was appropriate to consider as a basis for exclusion. In United States versus Faribi, a probation officer went to a location with a police officer to conduct a probation inspection. When they got there, the person who that was on parole was not, probation was not Faribi, but another individual. They approached that individual. That individual disclaimed any ownership or knowledge of a backpack that was in the premises. A search of the backpack ultimately revealed the presence of contraband, and the Fourth Circuit said that the conduct of Faribi in abandoning the backpack deprived him of any ability to thereafter challenge the search of the backpack. In Kansas versus Glover, the Supreme Court upheld as a proper inference a police officer who sees or learns that a vehicle is being driven by an individual to whom the vehicle is registered, and then they run the registration and find out that the individual's driver's license is revoked. That fact is deemed sufficient for the police officer to infer that the owner of the vehicle is the driver of the vehicle and thus justify a stop and then after the stop, all the other stuff happens. What the court does say, however, is that in this particular case, the officer lacked any information negating the inference. So presumably, if the registration came back to a man and the officer saw that it was a woman driving, that would be the type of information to negate the inference. But in the absence of negating information, they upheld this stop. In Torres versus Madrid, which isn't a criminal case, but is a 1983 case, the Court of Special Appeals will be considering whether—
The Supreme Court, Bob.
Sorry, what did I say? Oh, Supreme Court, thank you. Will be considering whether an unsuccessful attempt to detain a suspect by physical force constitutes a Fourth Amendment seizure. In this case, the police were chasing somebody, shot at them, but there was no actual physical apprehension of the person. And the issue there was, by using this kind of force, was that sufficient to implicate a Fourth Amendment seizure? This one.
All right, this is me. Now we're switching to the confrontation clause. In Rainey versus State, the Court of Special Appeals decided this case. Here, what happened was the defendant pleaded guilty to facts constituting the actus reus of first-degree murder. However, the defendant elected a jury trial to determine whether or not he was criminally responsible for his actions. During the jury trial, the state presented an expert witness, a forensic psychiatrist, who offered testimony about the defendant being criminally responsible. In offering the testimony as well as different reports, the witness introduced testimonial hearsay of other experts who had examined the defendant. And one of the tests that was examined by somebody who was not a witness indicated that the defendant was malingering, well, after initially being found not competent to stand trial, basically that he was feigning this. And the objection by the defendant was that he didn't have the opportunity to cross-examine the expert who actually performed the test and came to this conclusion, and this was all being introduced through some other expert. The Court of Special Appeals determined that this was testimonial hearsay. They considered something called the primary purpose test, which is, whether this type of medical or doctor-patient relationship existed, or whether there were statements being acquired solely for the purpose of later being used in a criminal action. And the type of evaluation that Mr. Rainey had undergone was definitely for purposes of the criminal case. However, unfortunately for Mr. Rainey, the court ended up finding that the error was harmless, and that was because of a couple of things. First, the doctor who prepared the report, the doctor who testified, he was subject to cross-examination, so the court felt like the defense attorney could have questioned that doctor on some of the statements. Other statements that were in the report indicated that the defendant had not been lying or malingering. So the Court of Special Appeals felt that that kind of balanced out some of the damning statements. But then also there was other independent admissible evidence that the testifying witness relied on to support their opinion as to why Mr. Rainey had been feigning his incompetency. And so for all those reasons, the court found that the error was harmless. However, the court made some other important findings that when you are looking at Rule 5703, the rule on experts and reports and how hearsay can be considered by an expert, that has to be balanced against the confrontation clause. And if the two are at odds, the Court of Special Appeals said that the confrontation clause is going to prevail. So remember that when you are assessing the reports in your cases, see if there's a primary purpose for criminal action, use in a criminal action, or if the evidence is non-testimonial. In United States versus Benson, this is a case in the Fourth Circuit, a federal case. In this case, 4 individuals were charged with the shooting and killing of a victim. And like many defendants who commit crimes, they went out and talked about it with friends, with family, with cellmates, and even with the police. The trial was a joint trial. One of the defendants ended up being a cooperating witness. The other three were tried together. And during the trial, there were about 4 or 5 statements that were introduced against the other defendants. And the defendants all made objections that these were brutal statements, that they violated the confrontation clause. The Fourth Circuit went through each of the statements and explained why Bruton was not implicated and why it was not a violation of the confrontation clause. Basically, any statements that were made to the friends or that were made to inmates are never considered testimonial. So those arguments by the defendants went right out the window. There was a close call with respect to statements that were made to the police officers that were then introduced against the other defendants. And the way that the Fourth Circuit saved those statements for the prosecution was the Fourth Circuit said that those statements did not facially incriminate one of the defendants. I'm not sure that I, as a defense attorney, agree with that holding, and the Fourth Circuit did say that it was a close call. In that case, what happened with that statement, the witness told the police that he and others took Brian Brown's truck, but the Fourth Circuit said that the witness never said that Brian Brown was present, that he approved of them taking the truck, or that he knew that they had taken it. And so the mere possibility of involvement did not rise to a facially incriminating statement.
The court has considered a couple of cases on speedy trial grounds. In Phillips versus State, the state had taken an interlocutory appeal, and the process of that the delay caused by that interlocutory appeal was challenged by the defendant. In this case, the court found that they would assess the reasonableness of the taking of the interlocutory appeal, the strength of the government's position, and the importance of the issue. And because the appeal was not considered to be tangential or frivolous, they concluded that the time would not be weighed against the state, and said the defendant failed to meet the burden of showing that the state had acted in bad faith. In another case by our leadoff speaker here, Judge Jeter, an NCR plea was filed by a defendant 16 months into trial preparation. The state then wanted the opportunity to have an expert evaluate the defendant for NCR purposes, and the court concluded that the delay associated with that was neutral in the Barker speedy trial analysis.
All right. Pending before the Court of Appeals is a case called Funes versus State. And the issues here are, did the trial court err in denying the petitioner's motion to exclude the chemical breath test where a Spanish-speaking petitioner was advised of his right to decline the test in English? The second question is, did the trial court err in denying his motion to exclude the standardized field sobriety test where the petitioner, again, was a Spanish speaker, but the tests were performed in English? And this case appears to be coming directly from the Circuit Court for Montgomery County, so I don't have the benefit of additional facts to give you from a Court of Special Appeals opinion, but it will be interesting to see what the court does. Another case, this was a federal case, United States versus Gary, and this is all about the failure to inform the defendant of an element requiring knowledge of his status as a prohibited person regarding firearm possession. He entered a guilty plea, and during the plea colloquy, although the district court went over essential elements of the offense, the district court did not specifically advise the defendant that he had to know that he was a prohibited person from possessing a firearm. The Fourth Circuit held that the plea was therefore involuntary, that this knowledge element is required. Interestingly, though, today, Bob got an email in another case that he has indicating that United States versus Gary is going to cause the stay of some other proceedings because now the government has filed a petition for a rehearing in the Fourth Circuit. So we'll see if the Fourth Circuit changes its opinion.
And that this case could result in an awful lot of post-conviction 2255 petitions. I'm seeing them being filed in cases, it looks like the federal public defender may have identified those cases where people have pled guilty to being a prohibited person and where the colloquy did not include an advisement of this element. There is an effort underway to vacate those, and it could affect an awful lot of cases. In the case Megan mentioned, I'm not sure it affects ultimately the cases where you have a person who was convicted of a drug offense and a gun offense and got concurrent time, but they still are vacating those convictions, and they may have other collateral benefits to individuals if those are successful. In Kaler versus Kansas, the Kansas court determined that it would make a determination of criminal responsibility based on what, by choosing one of the two tests that the Supreme Court said it had the option of testing. One was the moral incapacity test. The way they defined that is whether a defendant illness left him unable to distinguish right from wrong with respect to criminal conduct, or the cognitive incapacity test, which was the Kansas test, whether the defendant was able to understand what he was doing when he committed a crime. And they concluded that the defendant only needs to understand the act he is engaged in. And so it's a much more limited sort of insanity test.
In Hemming versus State, which is pending in the Court of Appeals, this is an interesting issue about bifurcating separate counts between a judge and a jury in a single trial. In this case, the defendant sought to have a court trial on possession of a regulated firearm and possession of ammunition by a prohibited person, but to have the remaining counts tried by the jury. In the trial court, the court held that it did not have authority to bifurcate charges among judge and jury within one trial, and the court cited to Rule 4253C. In the Court of Special Appeals, the appellant and the appellee both relied on a Court of Appeals case called Galloway versus State, which was a case of bifurcation. However, the Court of Appeals didn't actually make a ruling with respect to the bifurcation in that case. Instead, the Court of Appeals left that issue for another day and indicated in its opinion that by doing so, it wasn't making a finding or a suggestion as to whether it would or would not approve of it. It also indicated that the rule did not say one way or the other whether that would be permissible. So that is the issue that is pending now before the Court of Appeals.
I'm not even going to try to pronounce the name of this case versus State.
That's why I gave you the case, Bob.
Well, I'm known for butchering names even when they're simple. So in this case, the issue was raised as to whether or not, as to a jury selection process, and whether or not you can challenge jurors from the box. In this particular case, the court reaffirmed that challenging a juror from the box is a well-established, well-recognized, acceptable procedure in Maryland. And although in this, but you have to make the request. If you don't make the request, then the rule requires that challenges be exercised simultaneously by striking names from a list. In this case, the court did not permit striking from the box, but because in this case, the court found there was no prejudice established by the denial of striking from the box, that there was no challenge made to the group of 12 before the alternate alternates were chosen, and because the the defense really didn't preserve this issue in any way to establish to the court's satisfaction prejudice or somehow or another that they would have exercised their challenges in a way different than they did, they basically said it didn't make any difference. This one was interesting, I thought. In this particular case of jury selection, the court asked the entire jury pool all of the questions from voir dire. Any juror who did not answer positively or negatively was then constituted the pool of jurors from which the ultimate jury would be selected. So there was no follow-up questioning of anyone who answered any question of voir dire. The Court of Special Appeals did not reverse this case, but it essentially criticized it and said, you really shouldn't be doing this. I mean, it's a pretty crazy procedure, I would think, but I'm guessing because there wasn't any strong establishment of prejudice in the record, they got away with it. But they were not they did not seem to be happy campers with the way that this particular jury selection process went on. Now we're going to do a series of evidence cases that Megan's going to handle.
All right, so first, State versus Sample, Court of Appeals case that dealt with Facebook evidence. This case essentially reaffirmed the holding in Sublet versus State, and it talks about authenticating social media evidence. Again, the standard is just, was there sufficient circumstantial evidence under the rules that the evidence is what it purports to be? In this case, the state established, based on that standard, that the defendant had a certain Facebook profile, that his accomplice had a certain Facebook profile, and what was relevant to the trial was the fact that right after the robbery, the defendant unfriended his accomplice, and that was the only person he had unfriended after the robbery over the course of the next 17 days. So it showed a consciousness of guilt, it showed association, and that was essentially the burden that the state had to meet, and it was easy for them to do so. Montague versus State is pending in the Court of Appeals. In this case, it's about rap lyrics and whether they can be proof of wrongdoing. The rap lyrics at question in this case were lyrics authored by the defendant about 1 year after the murder. I'm going to tell you what the lyrics were because it's important to your understanding of why the Court of Special Appeals found that it was relevant. So Montague, who was being prosecuted for second-degree murder and use of a firearm in a crime of violence, had rap lyrics that indicated that he would exact immediate retribution if cheated. He referred to a .40 caliber, bullets, and a pickup truck. He also said that anyone who cheated him would be picked up by the ambulance. In the case, the victim attempted to use counterfeit money to pay the defendant for drugs. The victim arrived at the crime scene in a pickup truck where .40 caliber bullets were found, and the victim was picked up by an ambulance after he was shot. And like I said, this was recited less than a year after the murder. The Court of Special Appeals found that these lyrics were relevant because they alluded to the details of the murder, they explained a possible motive, and they were more than just bad act evidence, they were actually direct proof of wrongdoing. So we'll see what the Court of Appeals does. All right, Wise versus State, also pending in the Court of Appeals. This is a case about a witness who suffered a traumatic brain injury, and that affected the way that they testified at trial. The witness had made observations about the defendant at the scene of the crime. The witness had gone to the police station and after a photo array identified the defendant's photo, wrote details about the incident on the back of the photo, signed his name. Years later, before the trial came to be, as I mentioned, the witness was involved in had a traumatic brain injury, which affected his ability to remember things. He was still found competent to testify at trial. During the trial, he provided what the state alleged were inconsistent details about the night of the incident that was at trial. The witness was actually confusing events between how he got his brain injury and what he had witnessed with respect to the trial. The state sought to introduce and did introduce his prior statement from the back of the photo that he had picked out. The defense had argued that it was not an inconsistent statement under Nance and under the substantive rule of evidence. It was not a prior inconsistent statement because it was not feigned memory. It was actual organic inability to remember. So there was a difference in terms of deception and whether it could be used, as a prior inconsistent statement. The Court of Special Appeals, however, said that had the witness merely testified that he could not remember, then the prior statement could not have been introduced as a prior inconsistent statement substantively. However, in this case, the witness didn't testify that he did not remember. He actually offered conflicting details. Now, the Court of Special Appeals was careful to say that this only applies to material inconsistencies. And I think the example that the Court of Special Appeals gave as to what would not be material is if the witness were to say that he had watched Blade 2 the night of the incident when in fact he had watched Dracula, that would not be the type of inconsistency that would then allow the state to introduce this statement. It has to be something material to the details of the crime. But that is now pending. Vigna versus State is also pending in the Court of Appeals. This is a case where the Court of Special Appeals held that appropriate interaction between a defendant and children is not a relevant, pertinent character trait pursuant to Rule 404. And the defendant objected to this. The defendant was on trial for committing sexual abuse of minors. He, I believe, was a principal or some sort of school teacher. And in the case, the state had actually been allowed to introduce prior bad act evidence of the defendant having inappropriate contact with other students. And so the defendant felt that he had the right to rebut that as and introduce pertinent character traits of appropriate interactions. The Court of Special Appeals acknowledged that the majority of other states that have considered this issue have allowed appropriate interactions with children to be introduced as pertinent character traits. However, the Court of Special Appeals decided not to apply the reasoning of those courts in this case and instead held that it was not pertinent. And so that is what the Court of Appeals will be deciding.
In United States versus Johnson, this case was reversed because the trial court failed to conduct what's called a Remmer hearing, which is a hearing to determine whether a juror is able to continue to serve as a juror and consider evidence impartially. In this case, there was evidence that defendant family members and defense witnesses in this street gang prosecution were using cell phones to take photos of jurors at the courthouse. And the Fourth Circuit said when that information came to the court's attention, the court had an obligation to do individualized examination of the jurors to determine whether or not it affected their ability to continue to fairly evaluate the evidence in the case.
All right, there are a couple of closing argument cases here. I can give a shot at the name. I think it's Pietrzewski versus State. And here, the defendant argued that the state shifted the burden of proof by commenting on witnesses called by the defendant and whether or not they were credible. What happened here was the defense put on alibi witnesses, and then in closing argument, the prosecutor attacked the credibility of the alibi witnesses, saying that the alibi witnesses never told certain information to the police. They could have provided details that they've now provided at trial. Why didn't they provide the information before? The Court of Special Appeals found that this was proper response to the evidence. It was not shifting the burden. It was merely commenting on what was presented at court. In a similar vein, Harrison versus State, another Court of Special Appeals case. Here, the defense in closing argument attacked the cell phone evidence that was introduced by the state, including the GPS information and the fact that it was never analyzed to determine the whereabouts of the phones or the people who were associated with the phones. So in rebuttal closing argument, the state asked hypothetically or to the jury, well, the defense counsel didn't talk about the phones. He didn't talk about the locations. He didn't provide you with information regarding GPS. And apparently it was the defense that had provided the records in the first place to the police. So the Court of Special Appeals found that defense counsel opened the door by his statements in closing argument, and therefore the prosecutor's remarks were proper rebuttal.
In Sales, this is a sort of a fascinating case that underscores the ability and the right of a jury to engage in nullification, but prohibits anybody from telling them that that right exists. So it's, as we know, it's improper for the parties to argue nullification. It's also improper to instruct the jury that they cannot engage in nullification. So you can't argue that they can do it, but the court can't tell them that they can't do it. And where that leaves it all is anybody's guess. In Hairston, the court concluded that it was not an abuse of discretion in this case to refuse to give a cross-racial identification, but this was decided on an abuse of discretion and on the facts of this case, where the eyewitness, although of a different race from the defendant, had known him for a lengthy period of time. So what it would suggest is that in the right case, that the proper exercise of discretion may be to give such an instruction. In Ramos versus Louisiana, the Supreme Court established that the requirement of that it is constitutionally required that a jury be unanimous in its verdict. This obviously doesn't apply to Maryland, where we've always had to do that, but it's an interesting case. And in Edwards versus Vanoy, which is now pending before the Supreme Court, they're going to have to decide whether that right applies retroactively to all of the cases that have been decided over some period of time where there's been less than a unanimous verdict. Now we're going to talk about some sentencing and probation cases.
So in State versus Alexander, the Court of Appeals held that in certain circumstances, a trial court does have the discretion to dismiss a probation violation or to terminate probation without a hearing. In this case, the defendant was violated, or a petition for the violation was filed alleging that he failed to pay restitution. He was arrested and held in jail for more than 15 days before the hearing, which is a presumptively reasonable sentence for this type of violation. So the trial court dismissed the violation. Now, the trial court erroneously believed that probation had already terminated, even though it had actually been extended. So the trial court ruled that probation was closed. And the Court of Appeals said that the trial court abused its discretion because it didn't realize that probation was still pending. So what the court did is it remanded it back for the trial court to determine if it should also terminate probation at that time. Schmidt versus State is a case where a defendant who was found not criminally responsible sought to have a probation before judgment be entered in his case, but the Court of Special Appeals ruled that the criminal procedure article that we all know, 6220, which is what gives a court authority to grant a probation before judgment, it doesn't apply to pleas of NCR. It only applies after a person is sentenced. So with an NCR, even though you're adjudged guilty, you then are found to be not criminally responsible, versus when you are found guilty and then a sentence is imposed. So there was no relief for a person found NCR. In Bratt versus State, a defendant was challenging the trial court's failure to award him credit for time served, and the Court of Appeals is telling all of us the proper procedure for fixing that. It's not a motion to correct a legal sentence under 4345 because it's technically not an illegal sentence. It's just a technicality that needs to be fixed. Rather, the appropriate rule would be 4351, which governs the maintenance of commitment records. Clark versus State was a case where the trial court sentenced the defendant to 2 consecutive sentences for a single act. The defendant was charged and convicted with possession of an assault weapon, as well as possession of a firearm by a person previously convicted of a felony. but it was just one gun that the defendant was accused of possessing. And the defendant made all of these arguments, and the Court of Special Appeals considered all of these arguments about merger, double jeopardy, required evidence test, the rule of lenity, fundamental fairness, but ultimately found that the General Assembly intended for these two offenses to be sentenced separately. And so he was given two consecutive sentences. This is you, Bob.
Okay.
Brown.
So in Brown versus State, which is pending before the Court of Appeals, the question is whether the court has the authority to modify a mandatory minimum sentence that was imposed before September 30, 2017, when a defendant was entitled, because of new laws, to go back and try to have a mandatory drug sentence reconsidered. What happens, however, where the initial negotiated sentence was a binding plea agreement, the state does not consent, and or the defendant waived his right to seek modification of the sentence as part of the plea agreement. In State versus Frazier, the court will have to consider, pending before the Court of Appeals, whether it reconsiders the State versus Lancaster decision that holds that where two offenses are the same for double jeopardy purposes, the question is going to be whether the court is limited to what might be a lesser sentence, to the lesser sentence in a situation where they are deemed both the same for double jeopardy purposes. I had a case a few years ago where my client was charged with first-degree assault and with convicted of involuntary manslaughter, and the question there was he subject to 25 years in jail or 10 years? And because of the double jeopardy principles, in that case, the court was limited to a 10-year sentence in that case. And so this will reconsider whether that's going to continue to be the case. In Alleman versus State, also pending before the Court of Appeals, Maryland obtained custody through the Interstate Act on Detainers from an inmate from Ohio. The person was found NCR in order committed in Maryland. And the question is, does Maryland keep him, or does Maryland have to return him to the sending state to complete the sentence there before the NCR finding has whatever consequence it has to the defendant going on? Jones versus Mississippi is the court's going to have to consider whether the Eighth Amendment requires a sentencing judge to make a specific finding about the incorrigible nature of a particular juvenile before they can justify the imposition of a life without parole sentence.
All right, now we're moving into Brady violations. Canales-Yanes versus State is pending in the Court of Appeals and has somewhat of a unique set of facts. This was a court trial where the defendant was convicted, after which, prior to sentencing, the state produced for defense counsel a previously undisclosed recorded interview and transcripts that the defense counsel alleged were material, were exculpatory, and were a Brady violation. The trial court determined that even with that information in this undisclosed interview, had it been presented to him during the course of the trial, it would not have affected his verdict. He still would have found the client guilty because there was substantial or overwhelming evidence as to the defendant's guilt. The issue before the Court of Appeals is when a Brady violation occurs during a bench trial, is the test for materiality satisfied simply by the judge's determination that his verdict would not have changed had the evidence not been suppressed? Or should a trial court give consideration to the effect that the suppression of the evidence could have had on the defense's preparation and trial strategy? And so the Court of Special Appeals somewhat seemed to just adopt the trial court's finding that his own personal viewpoint wouldn't have been changed. And so the Court of Appeals now has to determine, is that really the sufficient test, or should it be a broader determination in deciding materiality? Bird versus State is another Brady violation case. This case is different because it's not in the context of a trial, but rather in the context of entering a plea. Here, the defendant entered a guilty plea. It was a case that the witnesses would have mostly been police officers. It turned out that after the plea, he discovered that the officers had a history of lying in federal court and falsifying warrants. The defendant alleged that this was a Brady violation, that he otherwise was induced to enter into this plea, and that the non-disclosure of this information should require the reversal of his conviction. The Court of Special Appeals, however, held that it did not warrant setting aside the plea. The trial court and the Court of Special Appeals seemed to draw a distinction between Brady violations in the context of preparing for trial versus Brady violations in the context of deciding to plead guilty. And so the Court of Appeals now has to decide those issues.
Now we're going to go to a series of post-conviction related cases. In the Peterson case, the Court of Appeals determined that post-conviction is not available for an individual who has been found guilty, but then determined to be not criminally responsible. However, they leave open the possibility that there may be other habeas corpus relief available pursuant to 3702 of the court's article. It's not clear exactly how that's going to translate into what happens when the person gets back into court, but they noted that there are some that option is still available. In Faulkner, which was a lengthy case and a very controversial case, I think, as it worked its way up to the Court of Appeals, the Court of Appeals concluded that the test was made in this writ of actual innocence, and that the evidence in this case met the test for the granting of an actual innocence reversal, applying the standard that there was a substantial or significant possibility that there was a material evidence that went to establish the client's innocence. The court concluded that the circuit court abused its discretion by using an incorrect legal standard in its analysis and application of this test to the evidence that had been presented. In State versus Day, this is one of a series of cases that dealt with the issues of reconsideration of a sentence. In this case, the trial court had found that the defendant on his attempt to post-convict his trial counsel failed to offer what the court called competent evidence that he had asked his trial counsel to file a motion for reconsideration of sentence. So the Court of Appeals is going to consider what type of evidence and how specific direction must be to trial counsel from the defendant to file a motion for reconsideration of sentence. In the Franklin,
go
ahead.
Sorry. In a similar case, in Franklin versus State, the Court of Appeals will also be deciding, is it ineffective assistance of counsel for defense counsel to timely file a motion for modification of sentence requesting that it be held sub curia, but then to never secure an actual hearing on that motion in court in the ensuing 5 years. And is a finding that it does not constitute ineffective assistance inconsistent with the Court of Special Appeals decision in Moultrie versus State.
And this is going to be an interesting case in terms of what trial counsel has got to do in figuring out how long you're responsible after you've provided trial representation to somebody. You filed the motion. Are you on the hook to represent this person forever, or is there advisement that must be given about their independent responsibility to seek the hearing? So this is going to could very well affect all of us in a very broad way.
In Padilla versus State, which is pending in the Court of Appeals, the post-conviction court found that the defendant's attorney was ineffective both for failing to disclose a conflict of interest as well as failing to correct inaccurate immigration advice. However, the difference in this case from Prado and Padilla is that in this case, the defense attorney actually told the defendant to go seek an immigration attorney for advice. The defendant did go seek advice from an immigration attorney, and the defense counsel never conferred with the immigration attorney about that advice. Now, it turns out that the advice provided by the immigration attorney was not accurate. The post-conviction court held that defense counsel should have realized that the immigration attorney's advice was not accurate based on the plain language of the statute. But the Court of Special Appeals found that a defense attorney shouldn't be held to that standard. They shouldn't be second-guessing the, quote, experts in the field who are the immigration attorneys. And so pending in the Court of Appeals are the following questions. When the plain language of the immigration statute is clear, must counsel correct a client's known erroneous belief regarding the availability of immigration defenses? Number 2, does the Sixth Amendment apply to immigration advice obtained to assist in evaluating a plea offer? And number 3, did the Court of Special Appeals wrongly overturn the post-conviction court's findings of facts and misapply the third prong of Mickens versus Taylor, which is the test governing conflict of interest claims? In United States versus Akande, this was a case where the defendant was provided erroneous advice about whether or not he could appeal after he pleaded guilty. He had filed a motion to suppress evidence, which was denied, and he discussed at length with his defense counsel that he would only enter a guilty plea if he could still have the right to appeal the suppression court's ruling. His defense counsel erroneously told him that he absolutely would have the right to appeal if he entered into an open plea, basically with no terms, no strings attached. The trial court went through its standard plea colloquy, which talked about waiving his right to appeal, but the trial court did not specifically get into whether or not he was giving up his right to waive the suppression court's ruling. Furthermore, it was unlikely that he ever would have been allowed to appeal the suppression court's ruling because it was not on a dispositive issue. And generally, the government's position is that it won't enter into a conditional plea agreement unless the ruling is dispositive. So that his conviction was actually reversed in habeas corpus review because of the prejudice that he suffered. He only would have taken the plea if he could have pursued the appeal.
In Antoine versus State, a case that underscores that victims under the statute now have certain independent rights to be heard and to be considered before the court commits to a binding plea agreement. Here, the court determined that the trial court erred by not affording a crime victim the ability to present victim impact evidence before giving final approval to a binding plea agreement. And so the matter got remanded back, and there'll be an opportunity for the victim to be heard, and the court will then have to decide whether or not to accept the binding plea agreement.
All right, so Bob, I see that we're at about our 60 minutes, but maybe we can zoom through the remaining cases that we have to keep our word. So Rogers versus State, basically the petitioner pled guilty to human trafficking, and the statute did not have any age requirements in it. The plea colloquy said nothing about the age of the victim, and there were no findings made by the trial court. So the defendant was not required to register as a sex offender where none of that information was present by statute in the plea or by the court. Another body is not permitted to make determinations as to the age of the victim. The court must do it beyond a reasonable doubt. United States versus Spivey, Fourth Circuit case. Essentially, if you are required to register under the sex offender registry and you are going to change states, you have to register. And if you fail to register, you can be prosecuted in the state that you departed, not just the new state that you arrived in where you failed to register.
In Taylor versus State, pending in the Court of Appeals, the court will be considering whether or not review should be based on an erroneously given anti-CS effect instruction. and whether it should be based upon the law that existed at the time the instruction was given or the law that exists now. And then there's also a real issue about whether there was a preservation of the issue when the instruction was objected to, but there were no grounds asserted, specific grounds to preserve the issue. Constructive possession in the Mosley case by Judge Moylan, always a lengthy and enjoyable kind of read. And in this case, Judge Moylan found that the evidence was insufficient to establish a knowledge and control of the premises where the contraband was found. It's a good read and review of the factors that go into establishing constructive possession or not establishing constructive possession.
All right, there are two recent involuntary manslaughter cases. In McCauley versus State, the Court of Special Appeals found that the evidence was sufficient to support gross negligence involuntary manslaughter. This basically jumps off of the Thomas decision, and it's a case about a woman who was a prolific drug dealer. She knew the lethal nature of the drugs that she was distributing. She knew that people were overdosing. She herself overdosed. She would tell people not to die. So ultimately, when one of the people, she distributed drugs to a man, but the man arrived with the woman, and it was the woman who ended up dying. And the Court of Special Appeals found that the evidence was sufficient to support gross negligence involuntary manslaughter. In State versus Morrison, this is pending in the Court of Appeals, and the Court of Special Appeals actually found that the evidence was not sufficient to support involuntary manslaughter. In this case, it was a mother who co-slept with her 4-month-old infant and had consumed beer prior to getting into bed. And unfortunately, she rolled over on her baby during the night, and the baby died as a result. The Court of Special Appeals found that the evidence was not sufficient to rise to gross negligence manslaughter. It listed that the woman had never previously lost a child in that manner. The woman did not know and understand the risks of co-sleeping with an infant. The woman was not a prolific drinker. There was no evidence that she routinely had substance abuse issues, and that a reasonable person would not expect this type of tragedy to occur. And so the Court of Appeals is basically just facing that issue. Was the evidence sufficient to permit a rational trier of fact to find that she was guilty of voluntary manslaughter? There was a hate crime case out of the Court of Special Appeals in which the defendant challenged the constitutionality of the statute, alleging that it violated his First Amendment right to free speech. And in this case, he had defaced property of another. What the Court of Special Appeals held was that you can do whatever you want to your own property. You can write on it, destroy it, give whatever symbols you want to it, but the minute that you destroy somebody else's, it's no longer protected free speech, and the statute is constitutional.
In State versus LZ pending in the Court of Appeals, the question will be whether the Court of Special Appeals was wrong in holding that a jury may not be instructed to find the victim abuse the defendant and the defendant suffers from battered spouse syndrome before considering expert testimony on the issue. State versus Wilson is an interesting case. In this case, a man and a woman get married right before the husband is supposed to go on trial for a murder charge, and the issue is whether or not the court can set aside an otherwise valid marriage because the purpose of the marriage was to avoid being compelled to testify against a spouse.
Pending in the Supreme Court is a case about accessing a computer. In this case, a police officer had authorization to access law enforcement records to do background checks on people. However, he accessed the computer for an unlawful purpose. He was paid by somebody to see whether another person was an undercover cop. And so the Supreme Court is deciding whether a person who is authorized to access information on a computer for certain purposes, if they access the same information for improper purposes, does that violate the statute?
And our last case, pending before the Supreme Court, is one in a series of cases that the court has been deciding on whether the use of force clause, whether the Armed Career Criminal Act applies in a variety of different kinds of instances. In this case, it's whether or not the use of force clause encompasses crimes that have a mens rea of mere recklessness versus a higher level of intent. And so slightly over 60 minutes, about 60 cases, and everybody be safe.